I was 30 minutes away from closing a $2.5 million deal when Cameron West walked into my office and handed me a termination letter. The ink wasn't even dry on the consolidated energy merger documents I'd been nursing for 5 months, and this 29-year-old trust fund kid was firing me to hire his girlfriend. Cameron West fired me to cover up his own mistakes after I spent 7 years building this firm's reputation and mentoring half the lawyers who work there. So I planned my response. In 60 days, the panic started. In 10 months, the firm was gone. I'm Tom Mitchell, 47, and I'd basically given my soul to Pierce & Associates, one of Houston's most respected corporate law firms. That Tuesday morning in March started like every other for the past 7 years. Coffee at 6:30, at my desk by 7, reviewing the consolidated energy merger documents for probably the 40th time. Our biggest deal of the year, worth $2.5 million in billings, and I'd personally shepherded it through 5 months of negotiations, while training 3 junior associates on complex corporate structuring. The morning felt different, though. Something was off. Rachel Anderson from Consolidated had called Monday afternoon with questions about force majeure clauses that any second-year law student should know. Basic stuff. When I asked who'd been handling her file lately, she paused. Some new person named Jennifer. She seems nice. Jennifer, Cameron's girlfriend, the paralegal who'd started 6 weeks ago and still needed help formatting basic contracts. The email came at 9:23, not from Harold Pierce, the managing partner who'd been stuck in Dallas all week dealing with another client crisis. This one was from Cameron himself. Subject line, urgent, see me immediately. Cameron was Richard West's son. Richard's family money had kept this firm breathing during the 2008 recession when half of Houston's legal market collapsed. The firm brought Cameron on 2 months ago as executive director after what they called an extensive national search. Truth was, the kid had failed the Texas bar exam twice, and his daddy created a position that didn't require a license. I saved my work and walked down the hall past the photos of the firm's founding partners. Men who'd built something that mattered, who'd earned their place through decades of grinding out victories in courtrooms and boardrooms. Now their legacy was being handed to someone who couldn't pass a basic competency exam. Cameron had taken over the corner office that used to belong to Janet Morrison, a senior partner with 25 years of experience who'd argued cases before the Fifth Circuit Court of Appeals. She'd been moved to a cramped space near the copy machine the day Cameron arrived. Nobody talked about it. We all just watched a woman who'd personally built half our Fortune 500 relationships pack up her diplomas while Cameron's interior decorator measured for a neon sign that said, "Think different." He didn't look up when I walked in, just sat there scrolling his iPhone, designer sneakers propped on his father's imported mahogany desk. The same desk where Richard West had built this firm's reputation one handshake at a time. "Tom," he said without raising his eyes, "we need to talk." I'd been Tom to everyone in this building for 7 years, senior associate, mentor to 12 junior lawyers, the guy who worked Christmas Eve and 4th of July weekends to keep deals moving. I'd given closing arguments that saved clients millions, had drafted acquisition structures that became templates for the entire Houston legal market. But something in his tone told me none of that mattered today. He slid a manila envelope across the desk. No explanation, no preamble, just papers with yellow signature tabs sticking out like tiny surrender flags. "Today's your last day. Jennifer will handle the transition." Jennifer. His 26-year-old girlfriend who'd worked at a digital marketing agency before this and thought due diligence was something you did before buying a car. The woman who'd asked me last week if liquidated damages meant someone had been hurt in an accident. "You're firing me the day before Consolidated closes?" I kept my voice level. 23 years of Navy JAG training doesn't disappear just because some rich kid decides to play power games. "Jennifer doesn't have a law degree," I said. "That's no longer your concern." His smile was all teeth, no warmth. The kind of expression you develop when daddy's money has cleaned up every mistake you've ever made since kindergarten. She brings fresh perspectives, innovative thinking. She understands disruption. Disruption. I let the word hang in the air. Like replacing a licensed attorney with someone who asks what consideration means in contract law. His face changed for the first time. Real emotion broke through the startup bro facade, something smaller and meaner than I'd expected. Watch yourself, Tom. You've got 1 hour to clear out, and that NDA is non-negotiable. You discuss any client matters, any internal information, and we'll destroy you in litigation. My father's firm has resources you can't imagine. 7 years. 7 years of 70-hour weeks, skipped vacations, working through the flu because a client needed emergency contract revisions. 7 years of building relationships with 23 corporate clients who trusted me personally, who called my cell phone at midnight when deals went sideways because they knew I'd answer. 7 years of mentoring young lawyers, teaching them how to structure complex transactions, how to read between the lines when negotiations got heated, how to protect their clients' interests even when the pressure mounted. I'd turned 12 recent law school graduates into competent corporate attorneys. Some of them were handling million-dollar deals now because I'd taught them the difference between legal theory and real-world practice. And this trust fund accident was handing it all to his girlfriend because she looked good in business suits and told him what he wanted to hear. "What's the real reason?" I asked. He leaned back in his chair, pressing his fingertips together like he'd seen in some TED talk about power poses. "You're old school, Tom. The firm is evolving. We need people who understand the new economy, who aren't stuck in outdated ways of thinking. The new economy where paralegals handle $50 million acquisitions. Jennifer has an MBA from Rice. She understands business strategy in ways you never will." I almost laughed. An MBA from Rice. Like understanding discounted cash flows qualified someone to draft acquisition agreements or navigate SEC compliance requirements. "She also understands loyalty," he continued, "something that seems to be in short supply around here." Loyalty. That was rich coming from someone who'd never earned anything in his life, who'd been handed a corner office and executive title because of his last name. I picked up the envelope, flipped through the termination agreement, enhanced severance package in exchange for a broader non-compete clause than anything I'd signed when I started here. They wanted to tie my hands completely, add restrictions that went way beyond my original employment contract. But Texas courts had been striking down overreaching non-competes for years, especially when the termination looked like bad faith. Getting fired so the boss's son could give your job to his unqualified girlfriend might just qualify as the textbook definition of wrongful termination. "Have your lawyer send the final version to mine," I said, sliding the unsigned papers back across his desk. "You're making a mistake, Tom. Sign now and walk away clean. Fight this, and I'll make sure you never practice law in Houston again." I stood up, straightened my tie, looked him directly in the eye. "We'll see about that." The walk back to my office felt different. 20 years in the military teaches you to recognize when the mission parameters have changed, when the rules of engagement shift beneath your feet. This wasn't about performance or budget cuts or corporate restructuring. This was about a spoiled kid consolidating power and eliminating anyone who might question his authority. I had 1 hour to pack up 7 years of my professional life. But they'd made a critical error. They thought they were firing an employee. What they'd actually done was declare war on someone who knew exactly where all their vulnerabilities were hidden. Security showed up in under 5 minutes. 2 guys I'd never seen before, which felt deliberate. No friendly faces, no awkward small talk with building security who knew me by name. These were hired professionals, probably from the same firm Richard West used when he needed to make problems disappear quietly. They didn't say much, just positioned themselves where I could see them while I packed. The message was clear. You're not trusted, you're not welcome, and you're being watched. Through the glass partition walls, the entire floor suddenly became fascinated by urgent emails. Heads down, fingers typing, nobody making eye contact. One of the junior associates I'd been mentoring for 18 months, Sarah Collins, looked up once, mouthed, "I'm sorry," and immediately went back to her computer screen. Word had already spread. I was toxic now, radioactive. Whatever story Cameron was spinning, it was working. I grabbed what actually mattered. My personal laptop with templates I'd built over years of practice. My phone containing personal contact information for 23 corporate executives. My contract law books filled with margin notes from 7 years of complex deals, and the framed photo of my daughter's law school graduation that had sat on my desk since she passed the bar 3 years ago. What they couldn't box up was everything that really counted. The relationships, the trust, the 2 a.m. phone calls where I'd walked CEOs through crisis management when their deals imploded. 7 years of knowing exactly which client needed reassurance and which one responded better to tough love. 7 years of remembering birthdays, anniversaries, children's names, personal details that turned business relationships into something deeper. None of that fit in a cardboard banker's box. The walk to the elevator felt like a perp walk. Past the commissioned portraits of 3 generations of firm founders, past the reception area where I'd brought dozens of clients over the years, past the conference room where I'd negotiated some of the biggest deals in Houston's corporate legal market. I pushed through the glass doors for what I thought might be the last time, carrying everything that remained of my professional identity in 2 boxes and a briefcase. By 3:15 that Tuesday afternoon, I was sitting in my home office in Bel Air, still wearing my suit, staring at those pathetic boxes like they might suddenly explain what had just happened. The house was too quiet for a weekday. My golden retriever, Murphy, kept looking at me from his bed by the window, confused about why I was home when I should have been closing the biggest deal of the quarter. The shock was starting to fade, replaced by something colder and more focused. Not anger exactly. Anger was emotional, and emotion clouded judgment. This was more like the tactical assessment mode I'd learned in the Navy, that ability to step back and analyze a situation objectively when everything was going to hell. I made a pot of coffee at 3:30 in the afternoon because sleep was going to be optional for the foreseeable future, and started taking inventory of what I actually owned versus what Pierce and Associates thought they controlled. The results were more encouraging than I'd expected. First, there were the templates and systems I'd developed entirely on my own time, using my own equipment. 7 years of refining contract language, building checklists for due diligence reviews, creating frameworks for complex corporate structures. All of it developed during evenings and weekends, all of it stored on my personal laptop, all of it legally mine. Then there were the relationships. 23 Fortune 500 executives who had my personal cell phone number and used it. People who texted me pictures of their grandchildren and called when their regular lawyers couldn't handle the pressure. CFOs who trusted my judgment more than their own legal departments because I'd proven myself reliable when million-dollar deals hung in the balance. And finally, there was 7 years of institutional knowledge that couldn't be transferred in any staff meeting or training session. Like the fact that Consolidated Energy's CEO had a clause phobia dating back to a bad acquisition in the 90s, which meant you had to walk him through every contingency provision personally. Or that the general counsel at Morrison Industries always scheduled major contract reviews on Friday afternoons because she thought better under deadline. Pressure. Details like that weren't written down anywhere. They lived in my head, built up through years of paying attention to client preferences and adapting my approach accordingly. My phone buzzed at 4:47. Text message from Sarah, the junior associate who'd apologized with her eyes earlier. Tom, can't believe what happened. Just wanted you to know. Cameron called an all-hands meeting at 4 o'clock. Said Jennifer is taking over all client coordination effective immediately. She's supposed to be the primary contact for everything from scheduling to document review to strategic planning. Problem is, she just asked the paralegal pool what consideration means in contract law, like the basic legal concept. We're completely screwed over here. I stared at the message for a long moment. Responding directly about internal firm matters would violate my confidentiality agreement. But Sarah wasn't asking for advice about clients. She was sharing personal observations about workplace conditions. Big difference, legally speaking. Sorry to hear things are difficult. Hope everyone stays focused on serving clients properly. Her response came back immediately. Tom, she's scheduled to present the Consolidated Energy summary to their board tomorrow morning. She's never even read the acquisition agreement. This is going to be a disaster. I set the phone down and walked to my kitchen window, looking out at my neighbor's perfectly maintained lawn. Somewhere across town, Jennifer was probably panic reading merger documents for the first time, trying to understand in one evening what had taken me 5 months to structure. Tomorrow morning, she'd be standing in front of Consolidated Energy's board of directors, 8 executives who controlled $3.2 billion in annual revenue, trying to explain complex corporate structures and regulatory compliance issues she'd learned about 12 hours earlier. It was going to be a bloodbath. By 5:30, I'd converted my dining room into a command center. 7 years of professional knowledge spread across the table, organized into categories: client preferences, regulatory requirements, industry connections, competitive intelligence. Not confidential files. Those belong to the firm legally. But my personal observations, my strategic insights, my relationship maps. I opened a new email account, tmitchelllegal@gmail.com, Not a competing law firm that might violate my non-compete agreement, just a professional contact point. Updated my LinkedIn profile to independent legal consultant, corporate and securities law. No mention of Pearson Associates, no violation of my confidentiality obligations. Then I sat back and waited for the phone to ring. I didn't have to wait long. The first call came at 6:23 that evening. Rachel Anderson, general counsel at Consolidated Energy, and she sounded stressed. "Tom, I just got off a conference call with this Jennifer person. She kept calling our acquisition a merger of equals when we're clearly the acquiring entity. When I tried to explain the distinction, she said, 'It's basically the same thing, right? No, this is a $47 million transaction, not a lemonade stand purchase. Technically, discussing specific client matters would violate my confidentiality agreement. But expressing professional concern for a colleague's situation, that was just being decent. I'm no longer with Pearson Associates as of today, Rachel. Can't discuss ongoing matters, but you might want to consider getting independent counsel to review everything before tomorrow's presentation.' The silence stretched for about 10 seconds. Then, 'Tom, what the hell happened over there? Bound by agreements. Can't get into specifics. But Rachel, you've got a board meeting tomorrow morning, right? At 9 a.m. Jennifer's supposed to walk us through the final structure and compliance requirements.' I closed my eyes, imagining that train wreck. 8 board members, including 2 former federal judges and a former SEC commissioner, listening to someone explain corporate law who'd learned it from Google the night before. You might want to have backup questions ready, technical ones, just in case. Coffee tomorrow afternoon? As friends? Absolutely, as friends. By 8 p.m., I'd fielded similar calls from 4 other clients. Word travels at light speed in Houston corporate circles, especially when something this unprecedented happens. I didn't reach out to anyone, didn't send any group emails, didn't violate any agreements. They called me. Each conversation followed the same pattern. I confirmed I was gone, noted I was restricted in what I could discuss, suggested they get independent advice, and made it clear I was available for friendship and professional consultation within appropriate boundaries. What I was really doing was letting them know I existed, I was accessible, and I wasn't the one who'd abandoned them. 3 days later, I was sitting across from Harold Pierce in a conference room that smelled like leather and success. Harold's firm occupied 2 floors of a building 8 blocks from my old office, close enough to share the same lunch spots, far enough away to maintain professional independence. Harold was 64, had built his practice from nothing, starting with a 1-room office near the Galleria in 1987. 15 attorneys now compared to Pierce and Associates' 45. But they'd survived 3 recessions by being smart instead of impressive, by focusing on expertise rather than mahogany furniture and marble lobbies. Independent consulting, Harold said, studying me over wire-rimmed reading glasses. Interesting timing. I maintain professional relationships with Houston executives, I replied carefully. Those relationships exist independently of any employment arrangement. Harold poured ice water from a crystal pitcher, his movements deliberate and measured. Cameron West called me yesterday morning, warned me about a former employee who might attempt to violate his agreements. Said any firm that assisted you would face aggressive litigation. My stomach tightened. This was exactly what I'd expected, but hearing it confirmed made it real. I told him his concerns were noted, Harold continued, and that his threats were rejected. I may have used slightly more diplomatic language. For the first time in 3 days, I felt something like hope. The arrangement we worked out took 2 hours to finalize. Independent contractor status, not employee, which kept my non-compete clause in legally ambiguous territory. I'd work my own client matters, build my own practice under their umbrella. Harold's firm would provide office space, administrative support, malpractice insurance coverage, and most importantly, legal protection when Pearson Associates inevitably escalated their campaign. They will escalate, Harold warned. Richard West has been the biggest player in Houston corporate law for 20 years. His ego can't handle this kind of direct challenge to his authority, and from what I've observed, his son is even worse. All the arrogance with none of the accomplishments to back it up. Before I could respond, my phone buzzed with a text message, then another, then 3 more in rapid succession. Rachel Anderson. Presentation was a complete disaster. Jennifer couldn't answer basic questions about regulatory compliance. Board voted to postpone closing pending independent legal review. We need to talk. CFO from Morrison Industries. Tom, urgent situation with the Hartwell acquisition. Current counsel missed filing deadline with Texas Secretary of State. Deals in jeopardy. Call me immediately. Unknown number. Mr. Mitchell, I'm General Counsel at Crawford Industries. Rachel Anderson suggested I contact you regarding representation. Are you available for new client consultation? Unknown number. Tom Mitchell. This is David Kim, GC at Pinnacle Manufacturing. Heard you're consulting now. We've had concerns about our current firm's responsiveness. Coffee. This week. Unknown number. Mr. Mitchell, Jennifer Rogers, Chief Legal Officer at Apex Holdings. Can we schedule time to discuss representation? I looked up at Harold, who was watching my phone screen light up with incoming messages. Crawford Industries, I said, reading the most significant name. $8 billion in annual revenue. 5,000 employees. They've been with a Dallas firm for 15 years. Not anymore, apparently. The next 48 hours moved at warp speed. The consolidated energy disaster had rippled through Houston's tight-knit corporate community faster than I'd imagined possible. Jennifer's board presentation hadn't just been bad, it had been legendarily, spectacularly awful. According to Rachel, Jennifer had confused debt financing with equity structures, couldn't explain basic tax implications of the acquisition, and when pressed on regulatory compliance requirements, had actually said, "I'm sure we can Google that later if it becomes important," to a board that included 2 former federal judges. The consolidated deal was officially suspended pending comprehensive legal review by qualified counsel. Their board had voted unanimously to terminate Pierce & Associates immediately and retain independent counsel for what Rachel called damage assessment and remediation. That independent counsel turned out to be Harold's firm, with me as lead consultant. But Consolidated was just the beginning. Morrison Industries' Hartwell acquisition was falling apart because Jennifer had missed a critical filing deadline with the Texas Secretary of State, a routine administrative requirement that any competent paralegal should have calendared automatically. The missed deadline triggered a 30-day delay provision that would cost both companies approximately $2.3 million in extended due diligence costs and financing fees. Morrison's board was furious. Their CFO, Janet Walsh, had called me directly Tuesday morning. "Tom, we've worked together for 4 years. You've never missed a deadline. Never. This Jennifer person has been our point of contact for 6 weeks, and she's already cost us more than we paid in legal fees for the entire previous year." Morrison Industries terminated Pierce & Associates that afternoon and retained Harold's firm for immediate remediation efforts. 2 major clients gone in 1 week. But that was just the warm-up act. The real avalanche started Thursday morning when word got out that Crawford Industries, one of Houston's most prestigious corporate clients, was conducting what they called a comprehensive review of legal service providers. Crawford had never been a Pierce & Associates client. They'd been perfectly happy with their Dallas firm for over a decade. But they'd been watching the Houston market, and the Consolidated Energy debacle had raised questions about the stability and competence of established firms. When Crawford's general counsel called Thursday afternoon to schedule a consultation, I knew we'd crossed a threshold. This wasn't just about Pierce & Associates losing existing clients. This was about their reputation collapse, creating opportunities with companies that had never considered changing firms before. By week 6, Pierce & Associates was hemorrhaging clients faster than Richard West could make damage control calls. But they weren't going down quietly. The lawsuits started flying like confetti at a New Year's party. They sued me personally for tortious interference with business relationships. They sued Harold's firm for conspiracy. They sued 3 clients who'd switched representation, claiming we'd all coordinated a campaign to destroy their practice. They hired Morrison & Associates, not to be confused with Morrison Industries, my client, the most expensive litigation shop in Houston. When you hire lawyers who charge $800 an hour to defend tobacco companies, you're not looking for justice. You're looking to bury your opponents under legal fees until they surrender from financial exhaustion. The morning the suits were filed, my phone rang at 6:47 a.m. Rachel Anderson, and she sounded different. Not worried, but energized. "Tom, I just got served with papers claiming I conspired with you to destroy Pierce & Associates. According to these documents, I'm being sued for the crime of hiring better lawyers. I'm sorry you got dragged into this, Rachel. Don't be. There's something you should know." The Houston General Counsel Coalition held an emergency meeting last night. Informal group of about 40 corporate legal departments. We share notes on outside counsel, discuss fee arrangements, coordinate on industry issues. I'd heard of the coalition but never worked with them directly. We voted to coordinate defense against these lawsuits, Rachel continued. Pool our resources, share legal costs, present a unified front. They can't intimidate one or two companies, but they can't take on the entire Houston corporate community. Within a week, the defense coalition had grown to 28 companies. Not some dramatic war room with battle plans and matching coffee mugs. Just a shared legal defense fund and a group of corporate executives who'd been overcharged by big law firms for years. All that quiet resentment had been waiting for a reason to organize. Pierce and Associates had just handed them one. The coalition hired Kellerman and Associates, a litigation boutique that specialized in making aggressive plaintiffs regret ever filing. Their managing partner, Sarah Kellerman, had built her reputation on one simple principle. If you sue her clients frivolously, she'll make sure you pay for the privilege. Meanwhile, something else was happening that Pierce and Associates hadn't anticipated. A bar investigator had started asking questions. It began with a formal grievance filed against me by a CEO whose family had been friends with Richard West for 30 years. Standard accusations, abandoning ongoing matters, leaving clients vulnerable, damaging client interests through reckless departure. Complete nonsense, but grievances have to be investigated regardless. The investigator was Margaret Foster, a 20-year veteran of the Texas State Bar who'd seen every variation of lawyer misconduct imaginable. She spent 3 hours questioning me about my termination, my transition procedures, my compliance with confidentiality obligations. Professional, thorough, absolutely neutral. Never hostile, never friendly, just methodically documenting every detail with the precision of someone who'd testify about her findings in front of the state's highest legal authorities. What Pierce and Associates didn't anticipate was that our response would include a detailed timeline of my termination, documentation of Cameron's supervision failures, and evidence that Jennifer had been performing legal work without proper oversight. Suddenly, the investigation wasn't just about whether I'd abandoned clients. It was about whether Pierce and Associates had engaged in unauthorized practice of law by allowing an unlicensed paralegal to coordinate complex corporate matters without adequate supervision. The bar investigator started asking uncomfortable questions. Who was actually reviewing Jennifer's work? What were her qualifications for handling $50 million acquisitions? Why had licensed attorneys been terminated while unlicensed staff took over client-facing responsibilities? Cameron's name kept coming up in the preliminary interviews, not as a target initially, but as someone whose management decisions had created the supervision breakdown that led to client harm. The investigation expanded. Every file Jennifer had touched over the past 2 months got scrutinized. Every missed deadline, every client complaint, every instance where unlicensed staff had made legal decisions without proper attorney oversight. The findings were devastating. 17 instances of improper delegation to unlicensed personnel. 11 missed deadlines with material impact on client matters. 4 cases where clients suffered actual financial harm due to inadequate supervision. And one spectacular example where Jennifer had accidentally forwarded an internal email to a client discussing how to cover up a mistake she'd made on their regulatory filing. That client, Pinnacle Manufacturing, was now suing Pierce and Associates separately for malpractice and breach of fiduciary duty. The firm's malpractice insurance carrier had seen enough. They announced they were dropping Pierce and Associates entirely, effective in 60 days. Finding new coverage with that kind of record, at any reasonable premium, was essentially impossible. Richard West tried one last desperate play. He announced his retirement and attempted to position Cameron as his successor, hoping to rebrand the firm around a next-generation leadership and innovative approaches to legal service. The remaining partners staged what amounted to a boardroom coup. They voted to dissolve Pierce and Associates entirely and merge with a Dallas firm, not a partnership, an acquisition. The Houston lawyers would become employees of the new entity. The Pierce name would disappear from the letterhead for the first time since 1987. Cameron didn't get to inherit anything. The Dallas firm made it clear during negotiations that his continued employment wasn't part of the deal. The lawsuits against me and the coalition settled quietly with no admission of wrongdoing on either side. But the settlement required Pierce and Associates to pay our legal fees. Every dollar they'd spent trying to destroy us through litigation, they had to reimburse. The coalition's final bill, $1.9 million in legal fees paid by the firm that had started the war. 12 months after that Tuesday morning when Cameron handed me termination papers, I was sitting in my new office as managing partner of Mitchell & Associates, a division of Harold's firm. My team had grown to 9 attorneys. 21 of my original 23 clients had followed me over, plus 8 new ones who'd never worked with Pierce & Associates. Crawford Industries had become our largest client, with a comprehensive legal services relationship worth $800,000 annually. I'd been invited to speak at the Texas Bar Association's annual conference about legal ethics and proper supervision standards. The Pierce & Associates case study was already being discussed in law school ethics courses as an example of what happens when firms prioritize personal relationships over professional competence. Cameron tried to get a job with the Dallas firm after the merger. They declined. Tried another firm in Dallas, then Austin, then San Antonio. Same result everywhere. When your name appears in state bar investigation records next to phrases like supervision failures and improper delegation, it tends to end conversations quickly. Last I heard, he was running some kind of cryptocurrency consulting business out of a shared office space in the Galleria. Seemed about right. The final piece fell into place on a Wednesday in March, exactly 1 year and 3 days after I'd walked out carrying my career in a cardboard box. My assistant knocked on my door. "Tom, someone here to see you. No appointment, but he says it's important." "Who?" "Cameron West." I leaned back in my chair, looked out the window at downtown Houston's skyline, thought about it for exactly 2 seconds. Send him in. He looked like hell. The designer clothes were gone, replaced by something off the rack that didn't quite fit. He'd put on weight, the soft kind that comes from too many takeout dinners, and not enough reason to stay in shape. "Sit down, Cameron." He took the chair across from my desk, the same power dynamic he'd used on me a year ago. This time, he seemed to understand the irony. "I don't know why I came here," he said, his voice barely above a whisper. "I guess I needed to see where it all ended up." I waited. My dad won't return my calls. Jennifer's been gone for 6 months. Found out she'd been seeing one of the Morrison & Associates lawyers the whole time we were together. He laughed, but there was no humor in it. "Pretty much sums up my judgment, doesn't it?" "What do you want me to say, Cameron?" "I keep thinking about that morning when I fired you. I was so sure I was making the right call, modernizing the firm, bringing in fresh thinking." He met my eyes for the first time. "Instead, I killed everything my father built." "Yeah," I said. "You did." The silence stretched between us. "I guess I wanted to understand how you did it, how you took everything apart so completely." I stood up, walked around the desk until we were face to face. "I didn't take anything apart, Cameron. I just stopped holding it together." I handed him one of my business cards. Thomas Mitchell, managing partner. My name, my title, everything he'd tried to take away, printed on expensive cardstock. "You fired me because you thought the job was easy, because you thought relationships were just files in a database that could be transferred to whoever you wanted. You found out the hard way that some things can't be handed off to your girlfriend." He stared at the card for a long moment. "For what it's worth, I am sorry. Not that it changes anything. It doesn't." He pocketed the card and walked toward the door. Didn't look back, didn't offer to shake hands, just shuffled out like a man walking to his own funeral. I watched the elevator doors close on what was left of his father's legacy. Then I went back to my desk and got to work, building something that would last. Turns out you can't buy competence or inherit respect. They have to be earned one relationship, one deal, one late night at a time. The best revenge against nepotism isn't destroying what they built. It's showing them what they never learned how to build themselves.